You're listening to Red Eye on Vancouver Cooperative Radio, CFRO at 102.7 FM.
At the recent forum Valuing Human Dignity, Challenging the Trafficking of Women, panellists were asked to answer the question, what do we do about human trafficking? We have two of the answers they provided. The first is from Naomi Minwalla, a Vancouver immigration lawyer. She discussed the ways Canadian law needs to change to protect women from trafficking.
There is no legislation in Canada that addresses the protection of trafficked persons. We have legislation that addresses the act of trafficking, in other words, criminal laws designed to prosecute and penalize the people who are trafficking. So that legislation is in place. We don't have any genuine commitment on the part of our government to protect those who are trafficked. And there are, in my view, three major impediments that have existed for a long time. And one is that in Canada, we have a very enforcement criminal justice framework. That's the paradigm within which our legislators have been working to design measures to address the protection of trafficked women. And as will become clear in the course of my presentation, we need a paradigmatic shift away from that criminal justice and enforcement centered framework. The second major impediment is tight-fisted immigration legislation that we have in place that often leads to treating trafficked persons as if they are offenders of our domestic legislation and not treating them as persons who are actually at risk. So that's the second major impediment. And the third one is the culture within our major enforcement institution, the Canada Border Services Agency, and I say that's the major one because that is the one in which trafficked women and children encounter when they actually surface in Canada. They usually surface before the Canada Border Services Agency, and they are in the business of removals in Canada. That is their agenda. They're in the business of removals. They're not in the business of protection. So the culture within which trafficked persons find themselves when they do eventually surface is an enforcement culture. So that really is a framework in Canada that ignores the fact that protecting trafficked persons is a migration issue, it's a human rights issue, it's a gender issue. What we're stuck with is a criminal justice framework that grew out of an international framework, which is also criminal enforcement centered. So just to take you back, in year 2000, there was a convention, the United Nations Convention Against Transnational Organized Crime. And that is really a penal-based convention for tackling transnational organized crime. It's in the title of the convention itself. Out of that convention, two protocols developed, one which is now known as the Palermo Protocol, and that's a protocol to prevent, suppress, and punish trafficking in persons. Okay? That's not a standalone instrument. It has to be interpreted together with the Convention Against Transnational Organized Crime. So this is the legal framework in which our domestic legislation has developed. It's come from the international realm down to the domestic level. And although the Palermo Protocol includes some measures for protection, they're discretionary measures. The measures that are within that protocol that are mandatory for countries to follow, and Canada is a signatory, has ratified the convention, are the criminal-centered provisions. So again, those are provisions that address the act of trafficking, but they do not address the protection of trafficked persons. Now, that international paradigm trickled down to our Canadian domestic legislation. So what do we have in Canada? We have criminal code provisions which have created a criminal offense for trafficking, and there's nothing in the criminal code that addresses the protection of trafficked women. The only thing that, in a kind of indirect way, provides any source of protection is really something designed to protect proof. It's not to protect the person, it's designed to protect proof. So, for instance, the ability of a of a witness to testify in video camera or outside of the courtroom. So the protective measure that is within the criminal code is a protective measure to protect proof, not to protect the trafficked person. We also have a trafficking offense in our own immigration legislation, which, by the way, today is the 6th anniversary of our new immigration legislation. June 28th, 2002 is when our new immigration legislation came into force, and with it came an offense of trafficking. So we have two big offenses, one in the criminal code, one in our immigration legislation, and neither has really been effective. Neither have been effective tools in tackling in any meaningful way the issue of trafficking, and in particular the issue of protecting trafficked persons. Both are designed to prosecute and to penalize. And I'm not saying that that's not an important part of tackling the issues. It is, but it's not the only part. And the problem in Canada is that the agenda of prosecuting and penalizing traffickers has completely eclipsed the corresponding need to protect trafficked persons. Now, in May of 2006, Citizenship and Immigration Canada brought into place some ministerial guidelines. Guidelines are not legislation, they're not even regulations, they're just policy. In May 2006, new ministerial guidelines came into place which created a new class. There's something called a temporary residence permit, and that permit can be used for a wide variety of reasons. It had never been used to issue to trafficked persons. In any event, what these new ministerial guidelines brought into place was the ability for Citizenship and Immigration Canada to issue a special temporary residence permit to people who they felt, after reviewing their applications, were trafficked persons in need of protection. Okay, so it comes in two stages, two potential stages. One is a short-term temporary residence permit up to 180 days, and then if on a secondary examination after the expiry of that permit, the officer feels that there is an ongoing need for that person to be protected, then the officer can issue a longer-term temporary residence permit, and that can in turn lead to permanent residency. Now, these guidelines came as a surprise to everybody. There was no stakeholder consultation, to my knowledge, before they were issued. And this sounds marvelous, doesn't it? Temporary residence permit, get the person 180 days, 6 months to figure out what to do, to get the counseling he or she needs, so on and so forth, and the possibility of permanent residence. Well, the devil is always in the details, of course. Once a person self-identifies herself with Citizenship and Immigration Canada, there must be a mutual, they use the term mutual and automatic consultation between Immigration Canada and either the Royal Canadian Mounted Police or Canada Border Services Agency. So there is an automatic, they use the term mutual and automatic consultation. Secondly, if the person has not yet been to the police, it may be difficult for the officer to verify all facts. And then thirdly, for the longer-term temporary residence permit, this would require, quote, more complete verification of facts in consultation with law enforcement. So again, the devil is always in the details. For those of you who don't know, in Canada, our Supreme Court of Canada has said there is no obligation on anyone in Canada ever to report crime. So a trafficked person who is seeking protection has no obligation to go to the police, report who has trafficked her. So these guidelines really, again, sugar-coated, looks nice, looks like we're finally moving in the direction of protection, but no, it's still very enforcement-related. And that is probably, and I can't commit to this, but it's probably one of the reasons why only 5 temporary residence permits across Canada have been issued, to my understanding. That information comes from the Trafficking in Persons Office here in Vancouver. So that's not surprising given the enforcement approach. And so the guidelines really ignore the fact that, well, a trafficked person may not actually want to speak to law enforcement, a trafficked person may actually feel she's being put more at risk by speaking to law enforcement, by cooperating with a prosecution. And I often like to use the example of, for instance, an abused woman who takes the courage to leave her household, goes to a women's shelter, and the women's shelter says, well, no, unless you report your spousal abuse to the police, we're not going to let you in here, we're not going to give you shelter. And that's really kind of a parallel example. Why should Immigration Canada shut the door on the person simply because they don't want to go to law enforcement? So again, sugar-coated enforcement approach, not meaningful. And really, that enforcement approach is inherent in the culture of Canada Border Services Agency. That is the institution that is most likely to encounter trafficked persons, but is also the least likely to react in a manner that appropriately addresses the problem. And I'm not out to bash Canada Border Services Agency. As I mentioned earlier, they are the institution in Canada that is responsible for removing people. That is their agenda, that is their business. They're not in the business of assessing cases to see whether or not this person needs a protection. But yet, that is the venue in which most trafficked persons are going to find themselves, and it's usually in detention. I do duty counsel detention matters in Vancouver on a regular basis, and the place where I most frequently find trafficked women is in detention. So what happens? They're picked up on an immigration violation, either because they have no right to be in the country, they don't have a passport, they're working illegally. All of those kind of offenses are offenses for which Canada Border Services Agency officers have the jurisdiction to issue a removal order right away. They don't have to go before an adjudicator. So what often happens is they're arrested, they're detained, they're removed. By the time I'm there as duty counsel, it's often too late. And so there's really no mechanism at that stage to assist trafficked persons. And the temporary residence permit that is within our immigration guidelines, again, is because it has an enforcement approach, most trafficked persons are probably going to be afraid of approaching Immigration Canada and applying for that temporary residence permit. So what happens? They go to the NGOs, they go to everybody who they've been going to for decades and decades, who are working on shoestring budgets to help them. And so we're back to square one. So I've been given notice that I need to stop, but just in conclusion, we have legislation in Canada that addresses the act of trafficking. We don't have legislation that addresses the protection of trafficked persons. There's a distinct lack of any meaningful approach to this issue in Canada, given that we continue to want to work within a criminal justice framework, a paradigm for which our parliamentarians are not shifting. And until they shift from that, we're not going to move forward. And until the culture within the institutions that trafficked persons find themselves shifts, we're not going to move forward.
You're listening to Red Eye on Vancouver Cooperative Radio, CFRO at 102.7 FM.